Hi, I'm Charlie with WealthQuest, and today we'll be discussing 5 of the common ahas clients have when we've reviewed their estate plans with them. The first common aha clients have is that they realize they don't have a plan, or at least it's not documented. This might be because they've just continued to put it off, or they've simply ignored it altogether, because death is not an exciting thing to talk about, especially with loved ones. But making sure that your wishes are well documented are a critical piece to any sound financial plan. And it will save your loved ones a lot of time, money, and headaches when they have to deal with your estate upon your passing. The second aha clients have is when we review guardian designations in their wills. So if they have minor children, it's not uncommon to name their parents or the kid's grandparents as guardians should anything happen to them. And while there's no question that these grandparents love their grandkids, asking them to assume this responsibility for upwards of 18 years might be an unfair ask. These grandparents may be in their 50s or 60s when the wills are created, and that could place them into their 70s or even their 80s by the time the grandkids graduate from high school. And so one of the common things that we hear people say is, well, they don't want to place a financial burden on siblings or a family friend, which is why they chose the grandparents. But if you do the proper insurance planning and you have the right amount of life insurance in place, that can alleviate the financial burden on a younger generation. The third aha comes with improper age gates in trust documents. So in trust, a common provision is to have age restrictions when the beneficiaries can take withdrawals from their shares. So a common one you might see is at age 25, at age 30, and at age 35. And you might think, well, let's just divvy up that share into thirds. But when you do the math and you factor in that these assets could quadruple in value over the next 20 years before that first age gate would kick in, a lot of clients realize that that may leave a larger withdrawal amount than they had originally intended for. So you might want to consider placing either more restrictions, more age gates in that document, or reassigning the percentages that the beneficiary can withdraw at each age. The fourth one is just having an incomplete plan or missing documents. So a will and last testament, a trust, power of attorney, living will, healthcare power of attorney, these are all different documents that do specifically different things. And so while not everybody needs each and every document as part of their estate plan, you want to make sure that you review your specific situation with a trusted attorney or financial planner to make sure that you have all the documents that are right for your situation. The last aha is related to outdated beneficiary designations. So you might have gone through all of the work and the time and the money to put together a well-documented estate plan, but you failed to update your beneficiary designations on life insurance policies or retirement accounts. And did you know that beneficiary designations trump anything else that you have in writing? So make sure that you're not leaving assets to an ex-spouse or to minor children directly, but rather that they are coordinated with the rest of the estate planning that you've put in place. As always, if you have any questions, let us know. We're here to help.